My name is LaHood. I'm with the Center for Constitutional Rights. For folks who aren't familiar with us, we're a nonprofit in New York founded in the 60s in support of the civil rights movement, and we do human rights work as well. We've done quite a bit of human rights work on behalf of Palestinian human rights and human rights defenders. I'm going to go ahead and save that. I'll talk about that tonight. What I want to talk about now is the work we're doing on behalf of solidarity activists, along with the Palestine Solidarity Legal Support Project, headed by Dima Khalidi, who is here, and in collaboration with others here as well, the National Lawyers Guild, AMP, and others. So suffice it to say about our human rights work that much of the importance of that work had to do really with raising public awareness and getting people's stories out there and providing opportunities for you all, for activists to mobilize around. As the BDS movement is growing, as protests of Israel's human rights violations are growing, so is the campaign to repress that activism and to silence it and to try to equate criticism of Israeli policies with anti-Semitism. One of the cases CCR has been defending is the case of the Olympia Food Co-op, which I think probably many of you are familiar with. The Olympia Food Co-op is a nonprofit in Washington State that not only provides good food to more people, but also has a long history of social justice work and of boycotts. In 2010, though, it deigned to boycott Israeli goods. The board unanimously, by consensus, made that decision. 5 of the 22,000 members of the co-op sent a letter to the board promising complicated, burdensome, and expensive litigation unless they ended the boycott. The board reminded those 5 people that they could actually bring it to a membership vote if they chose to. They did not. Instead, they sued the board. The lawsuit was identified by Stand With Us, which folks know is a national anti-BDS organization, as one of its projects months before the case was even filed. Stand With Us also produced and posted an anti-BDS video with 4 of the 5 plaintiffs. 6 months before the suit was filed, the Israeli Consul General from San Francisco went up to Olympia and met with Stand With Us, as well as the lawyer for the plaintiffs and some so-called Olympia activists. Again, this was before the case was ever even filed. After the suit was filed, Danny Ayalon, who was the Israeli Deputy Foreign Minister, was asked if the Israeli Ministry of Foreign Affairs had anything to do with the lawsuit or was involved, and his response was, I quote, "It is very, very important to make use of every means at our disposal, mainly legal means. And it's true, we are using this organization, Stand With Us, to amplify our power." So the case was brought to stop the boycott and for damages against 16 current and former board members of the co-op. So we filed what's called an anti-SLAPP motion. SLAPP is a strategic lawsuit against public participation. About half of the states have anti-SLAPP laws that can be used to try to defer the abuse of courts to chill free speech. The law in Washington State permits early dismissal of a suit that challenges an action involving public participation, such as statements of public concern. So if plaintiffs can't show they're likely to prevail, the suit will be dismissed and the defendants can get attorney's fees and, in Washington State, a $10,000 sanction. So last year, the court agreed with us and granted the anti-SLAPP motion and actually awarded $160,000 in sanctions because of the 16 defendants. Have appealed, so that's currently pending, but I do think that this victory helps send a message to people who are willing to abuse the courts to try to silence Palestinian human rights activism. Another success, actually, another means that people are using is Title VI of the Civil Rights Act of 1964. Zionist Organization of America and other organizations have brought several Title VI complaints to the Department of Education Office of Civil Rights, which attempt to create criticism of Israel on campus with anti-Semitism and a hostile environment for Jewish students. None of them, as Sarah said, has been successful thus far, although they still do chill speech on behalf of Palestinian human rights. So Title VI prohibits discrimination based on race, national origin, and color by any program receiving federal funding. It doesn't cover religious discrimination, but following lobbying by ZOA and others, the OCR, the Office of Civil Rights, announced that Title VI does cover discrimination based on actual or perceived ancestry or ethnic characteristics. So that would cover Jewish students. It would also cover Muslim or Sikh students as well. It was actually Kenneth Marcus who announced this policy in 2004 when he was at OCR, and in 2011 he founded the Brandeis Center, which has coordinated or supported these Title VI complaints ever since. In a recent op-ed, in fact, he encouraged people to file Title VI complaints with OCR for speech critical of Israel, highlighting their chilling effect as one reason to do so. Because of the chilling effect of not only the complaints, but also the year-long investigations by OCR, a group of us civil rights organizations wrote to the Department of Education asking them, various questions about these investigations and saying that they need to be closed. So the Office of Civil Rights responded that they would be closing the investigations with dispatch, and in August it closed all 3 of its UC, University of California, investigations, which is notable. Even better, the decisions found that much of the basis for the complaints of a hostile environment was actually First Amendment protected speech, and that could not support a Title VI complaint, even if it's personally offensive or hurtful to some people in the university campus. Of course, ZOA and others continue to abuse Title VI, and so we're still working on this issue. Even though, and also Title VI, even the threat of Title VI complaints can be intimidating, as we saw with Brooklyn College SJP. There was an event that they had at a BDS event featuring Omar Barghouti and Judith Butler. Even the fact that there was going to be a BDS event caused, City Council to threaten withholding funding of Brooklyn College. We had the Nadler and other members of Congress, along with New York officials, coming out saying this is the antithesis of academic freedom. The event ended up going forward, but afterwards there were complaints that people were either excluded or removed because they were Jewish or anti-BDS. You had Alan Dershowitz coming out saying their First Amendment rights were violated. You had Neil Scher, who was the former head of AIPAC, saying that he was going to file a Title VI complaint. And so that same day that he made that announcement, CUNY launched an investigation into what happened at the event. CCR helped represent the Brooklyn College SJP students in that investigation, and 40 witnesses later, the CUNY came out with its report exonerating Brooklyn College SJP. Of course, then 3 of 4 of the anti-BDS students got counsel at a big law firm who wrote a letter asking for discipline of the SJP students and the administrators involved. Hopefully that won't be happening, but student discipline has been happening on campuses. For example, at Florida Atlantic University and Northeastern, students who walked out to protest IDF speakers have been disciplined on campus. And that's, not even talking about the criminalization of protests like with the Irvine 11. So anyway, the Palestine Legal Solidarity Support Project is monitoring these acts of intimidation. They've documented over 55 against Palestinian solidarity activists this year, but they're also providing legal advice, resources for activists, and continuing to document the incidents of repression. DEMA, along with Barbara Harvey, will be doing a Know Your Rights workshop tomorrow. And if you need more information, you can go to PalestineLegalSupport.org. Thank you very much.